Good afternoon, people out in Zoom land. I can't see you all, but my name is Amina Merritt. I'm a staff attorney at Housing and Economic Rights Advocates, and today we're going to present legal rights of survivors in public and subsidized housing. I apologize if some of you thought this was legal rights of survivors in private and subsidized housing. It might have been my oversight in checking the materials before they got published, but this is all about public and subsidized housing. And I just want to make a note that we are asking people to sign in if you want to receive the PowerPoint and materials from this and the recording from this webinar. You can do that by putting your information in the chat box, and it will be sent to you at the end. And we also want you to understand that you're allowed to use a safe sign-in method if you need to. As a survivor, some of you may have safe at home PO boxes or other identifying information. And I want you to know that we're only tracking the participants for these workshops for our grant and funding purposes, so you can sign in safely and not have to identify yourself if you don't want to, or if you want to use an X. And I also want to give a plug for HERA's Domestic Violence Workshop Series. There are a total of 5 workshops in our Survivor series, including this presentation. We have domestic violence survivors' rights in home ownership, right to break the lease early, right to change locks, rights regarding rent and utilities, and this one regarding public housing. And so we are going to spend the next 25 minutes talking about these topics. What is subsidized housing and public housing? And what are your rights as a survivor in public housing? And what do you do with those rights as a survivor in public housing? And so the first topic, what is public and subsidized housing? And we're going to do a quick summary of the federal housing programs that exist, so that you can understand whether you live in public or subsidized housing. Some people, you'd be surprised, don't even know what type of housing they do live in. And we speak to tenants on our tenant team a lot. And one of our first questions is about the type of housing you live in. And we're going to talk later about how you figure that out. But so let's quickly talk about the federal housing programs that have been established by the U.S. Housing Act of 1937, the Housing and Community Development Act. And most of you may know that public housing involves Section 8. People always know about Section 8 vouchers, but some people don't understand that that's not the only type of voucher that housing and urban development provide. And this is a short list of the type of housing that Section 8 provides under the federal housing programs. There are housing choice vouchers where HUD makes payments to public housing authorities for low-income tenant rent, where the tenant chooses where to live. There are also project-based vouchers that stay with the particular unit and not the tenant. And then there's also Section 8 moderate rehabilitation payments that are made by the federal government to public housing authorities to allow landlords to rent to low-income tenants. And that's considered subsidized housing, where the federal government is subsidizing rents for landlords to provide low-income rental. There's also project-based housing. That's housing choice voucher home ownership, where HUD funds other than moderate rehab. And that is not to be confused with project-based vouchers. And the reason I want to summarize these particular housing programs is because the type of notice and the person who is required to give notice of the rights for survivors depends on the type of housing program it is, to say who is required to give the tenant notice of their rights as a survivor. And so you'll see here that under Section 8, VAWA notice, Violence Against Women Act. We'll cover that in a minute. It's supposed to be given to you by the Public Housing Authority, the same as if you live in project-based housing. VAWA notices are required to be given by the Public Housing Authority. This next slide talks about the HUD-VASH program, which is the Veterans Affairs Supplemental Housing. And that usually is a program that combines rental assistance, housing choice vouchers or project-based vouchers, along with case management and VA clinical services for homeless veterans. This next section we're going to talk about, it's not a housing program, but I'm emphasizing it because it's important to recognize that I'm sorry, I messed up my screens. There we go. Usually non-citizens and immigrants are excluded from federal housing because there's this rule called Section 214, and that excludes immigrants and non-citizens from federal housing programs. But there are many exceptions to Section 214 for eligible non-citizens who have a visa or who are DACA or have a green card, et cetera, other definite statuses under the immigration laws that do allow immigrants to live in federal housing. And also I wanted to emphasize that the Violence Against Women Act and the immigration laws give survivors immediate right to access public housing and the benefits, public benefits that exist. And so eligible survivors who have petitions for humanitarian asylum, special immigrant juvenile status, U visa, trafficking visas, you can immediately get access to public housing and the benefits of the public, like food stamps and things like that, if you have applied for protection. And these laws, the VAWA law parallels the ICE system for protecting victims and allows immigrants to be able to leave safely and try to get a green card. So that's an important exception to being excluded from the public housing laws. There's also a federal housing program called Supportive Housing for Elderly under Section 202 and the Disabled under Section 811. These are for nonprofit sponsors of housing for elderly and the disabled. And these are for construction and substantial rehab of rental housing. These are considered subsidized housing, not public housing, but subsidized. And those Violence Against Women Act notices are required to be given by the nonprofit or the other provider of that housing. Under Section 211 and Section 236, the landlord is required to notify the tenant of their rights under the Violence Against Women Act. These are properties that are below market interest rate loans, where landlords get 3% loans to rent to low and moderate income tenants. And these are usually small multifamily or single family homes where the rent is regulated by HUD. Tenants are still entitled to the VAWA and the Fair Housing Act notices, and they should be attached to the lease when you rent these properties. There's also housing opportunity for people with AIDS, and there's a special program for Native American housing where HUD gives grants to tribes for new acquisition, rehabilitation, loan guarantees, or technical assistance. These block grants that are given to local governments or to housing, to nonprofits to give housing to person and families with AIDS or HIV positive families. Those programs also require the provider to give notice to the tenant of their rights under the Violence Against Women Act. This next slide also talks about three other programs: the Housing Trust Fund, Home, Rural Development, Multifamily Properties. And I wanted to point out that your landlord may have layers of federal assistance to make the tenant survivor eligible for the protections under the Violence Against Women Act. The Housing Trust Fund primarily is designed to increase and preserve rental housing and home ownership for extremely low and very low income and homeless families. The Home Investment Partnerships Program is for state and local governments to acquire, rehabilitation, and build new housing for sale or rent for and for-profit landlords who provide tenant-based rental assistance. And then there's also the program for development of rural multifamily homes. All of those programs require the program provider, because those are subsidized housing programs, subsidized by the federal government. Those providers must give notice of the Violence Against Women Act and the Fair Housing Act. The same with McKinney-Vento. McKinney-Vento is the Homeless Assistance Act, and it provides supportive housing and services for the homeless in transition and to help promote independent living. And it also includes the Continuum of Care programs, which are 3 homeless assistance programs: Shelter Care Plus, SRO Section 8 moderate rehab, and supportive housing. So those are most of the programs that are covered, federal programs. And it's important to understand that all of these programs are covered by the Violence Against Women Act. It's just important to know which program, to know who is required to give the legal notice of your rights under the Violence Against Women Act and the Fair Housing Act under federal law. And so I'm pointing out the National Property Database. I will provide the link to that. I thought it was on this page, but it will help identify your property and determine what federal programs or federal credits the landlord for that property receives. And if there are any federal subsidies or tax credits or federal programs that exist for that property, then the federal laws apply: the Violence Against Women Act and the Fair Housing Act. So the type of federal housing determines who must give notice. It could be the landlord, it could be the public housing authority, it could be the housing program or any other provider. And I should point out that if you have an old lease prior to 2021, it should be amended by your landlord to give the VAWA notice. And that's an important legal point that some landlords don't realize, that they have a duty to update their leases and to provide the VAWA amendment so that survivors have notice of their rights in public and subsidized housing. So now we're going to jump to topic number 2, which is, what are the survivor rights in public and subsidized housing? Remember, we're talking about federal housing programs, and so state laws do not apply. The federal law applies in these federal housing programs. And so the Violence Against Women Act is the primary protection for survivors, found at 8 U.S. Code Section 1367. And that law states that it is illegal for a covered housing provider to deny, terminate, or penalize a tenant who is a survivor. And so the main language here, covered housing provider. That's the reason I went through the federal housing programs, because those programs are covered housing providers, and they are subject to the Violence Against Women Act. And so they cannot deny you housing because you're a survivor. They cannot evict you because you're a survivor, and they cannot harass you or otherwise try to impose duties on you because you are a survivor. This shows you that VAWA is intended to encourage survivors who live in public or subsidized housing to report and seek help for the abuse against them without being afraid of eviction. It applies to survivors. This is important. Just because it's called the Violence Against Women Act doesn't mean it only applies to women survivors. It applies regardless of sex, gender, identity, or sexual orientation, and even the perception that you have a certain sexual orientation. And it also applies to the protected categories under the United States Constitution. There's a typo here in the word duties, but it imposes special duties on federal housing providers, including public housing authorities, management, landlords, housing organizations, and anyone else receiving a federal subsidy, a tax credit, or benefit to the housing. And that means the Violence Against Women Act applies. The rights that exist under VAWA: it prevents the public housing authority or landlord from discriminating against victims when renting to them. And if you're a tenant, it allows you to move without penalty. We have a special series that I mentioned earlier about breaking the lease. And that's a special presentation that will be given by HERA as how you can break your lease under VAWA without penalty. You can also you cannot be evicted for making excessive police reports. At HERA, we have seen people who've received eviction notices because they call the police too many times with related to domestic violence. So the Violence Against Women Act prohibits discrimination against housing providers against survivors of domestic violence. And it points out that an incident of domestic violence does not constitute a serious or repeated lease violation by the victim. So some leases have these clauses that a nuisance clause or a noise clause, and can try to evict a tenant claiming that because there's domestic violence in the unit, that the tenant is committing a serious or repeated lease violation or a nuisance, and that's good cause to evict the victim. VAWA specifically says that that is not the case, and that you cannot evict a survivor because there's violence in the home and the police are being called. And a person cannot be denied housing or assistance based solely on criminal activity that is the result of their status as a survivor, or the survivor may even have criminal history resulting from incidents that are the abuse. And you cannot be denied housing because of that criminal history. In fact, there's a move in housing, the housing industry, to try to prevent landlords from even inquiring into a person's criminal history, but that's a different topic for a different day. The Violence Against Women Act requires you to receive notice at the time you lease or rent an apartment of the protections, and there is a specific addendum that exists by law for landlords to provide that. It requires them to keep the tenant's status as a survivor confidential. It allows the housing provider to split the lease and evict the abuser so that the survivor can stay, and the remaining tenant, generally that the abuser can get 90 days to establish eligibility for that program or for another covered housing program or to find alternative housing. And it also requires that survivors have access to an emergency transfer plan to move without providing 30 days notice. And you're allowed to transfer your Section 8 voucher to another housing authority, to port your voucher to another county, and to have assistance to do that. And it also requires language access for monolingual speakers, VAWA notice in the language of origin. So if you're a Spanish speaker, your VAWA notice should be, and your lease should be in Spanish. And it gives immigrant survivors, as I said earlier, access to public housing benefits. To obtain protection under VAWA, a survivor has to provide documentation of the violence. You get to choose the documentation option, and under the 2022 amendments to VAWA, any credible evidence is enough to prove that you're a victim. Housing providers have to accept whatever documentation the survivor gives. There's this HUD form 5382 that is your self-certification of domestic violence. And you don't necessarily have to contact the police or initiate legal proceedings like a restraining order to prove that you are a victim. Police report is not required, but it does help support. Restraining order, temporary or permanent, is not required, but it does help provide protection for survivors. A statement from a qualified third party, for example, a victim service provider, medical provider, or mental health provider, can support victimization under VAWA. So now we're moving to our final topic. What do you do with those rights? What are the practical remedies that a tenant survivor has under the Violence Against Women Act? You get safety in the tenancy. Landlords and housing authorities and management have to work with you to improve home security. And a tenant can do that by making a written request that the landlord or management install high quality locks on doors or windows, or even change the locks on the apartment. Increase lighting, trim the shrubbery so people can't be hiding to attack you. And they can also assist you with a safety or escape plan if you're planning to move. The statistics show that one of the most dangerous times during a domestic violence survivor's life is when they decide to leave. And it's important to have a safety or escape plan that includes all of those people who can help you implement it. And landlords are required to work with you to develop that. The Violence Against Women Act addresses safety moves for survivors with vouchers. The housing authority has to ensure that the victim, not the perpetrator, retains the federal housing assistance. And a family can move to protect the health and safety of the victim and can violate the lease if the victim reasonably believes that they are imminently threatened with future violence. You can request that the voucher be transferred to your name only if the voucher has the abuser's name on it as well. So the voucher can be split. You're entitled to have confidentiality. If you move and you get a new address, the old landlord has to keep your new address confidential. The new landlord has to keep it confidential. There are mechanisms to enroll in address confidentiality or a mail forwarding program. You can obtain a post office box through California's Safe at Home program. Or you can list an address of a trusted friend or family member, or write confidential in the address portion of a restraining order application or other applications to keep your address confidential. And if you obtain a restraining order, you can request that the court order prohibit the abuser from taking steps to learn the new address. There's even a box on the restraining order form for the court to order that the abuser not try to find out where you live. The landlord in the federal housing program must keep even your status as a survivor confidential under the Violence Against Women Act. So a police report showing alleged abuse within the last 180 days can get you protection as a survivor of domestic violence. If you applied for a restraining order within the last 180 days, if you have a letter from a qualified third party, a doctor, a domestic violence counselor, a therapist, confirming that assistance was sought for physical or mental injuries or abuse. And as I said before, there's an exception for survivors in these federal housing programs where after 2022, you self-certify that you are the victim of domestic violence. And next point is that domestic violence is an affirmative defense in an unlawful detainer lawsuit. If the landlord seeks to evict the tenant can evoke the protections of the Violence Against Women's Act and the Fair Housing Act as affirmative defenses. And especially, as I mentioned earlier, the landlord may be trying to say that the tenant created a nuisance. And unless the housing contract, some Section 8 or federal housing programs have a HAP contract, and unless that some other language applies, all landlord-tenant laws still apply and must be followed by the landlord. I want to state a caution. If you're a survivor, you must not violate your restraining order and a 3-day notice to cure, because then the landlord can evict you if you violate the restraining order and let the abuser back into the apartment. And there also is a caution if the abuser is an unauthorized tenant, not supposed to be living in the apartment, and you let them in. Additional federal laws that protect survivors' housing, 42 USC Section 3601 is the Fair Housing Act. It's the Federal Housing Act. We also have one in California, FEHA, Fair Employment and Housing Act, but this is the federal act that provides discrimination, protections against housing discrimination based on race, color, religion, national origin, sex, disability, familial status, and veteran status. That's another layer of federal protection if you live in a federal housing program. And these federal housing programs under FEHA, under the Fair Housing Act, you have the right not to have your application denied for housing just because you're a survivor of domestic violence, or because of poor credit, rental history, unpaid rent, or utility debt, or a prior lease violation that is a direct result of the domestic violence. So if you're saying that you have poor credit because you were financially abused, then you may be able to rent. So are you denied housing? You have the right to understand why and to challenge the basis for that denial. You should ask for an explanation in writing. Is there any direct evidence of discrimination, comments, conduct, practices? Is there a policy like ads saying no Section 8 tenants allowed? That's illegal. And so if you have that problem, you should consult a private attorney about suing for discrimination. The places to complain about VAWA violations: public housing grievance with your local public housing authority, informal review and hearing, public hearing locally, the rent board, the HUD Office of Fair Housing and Equal Employment, And the U.S. District Court is where to file a complaint against a federal housing employer, where you could possibly also include state claims under the Fair Employment and Housing Act, the Unruh Civil Rights Act, and other state laws that a landlord may violate, where you can include federal and state claims together. We're coming to the end of our time, but the civil lawsuit under the Fair Housing Act, or VAWA, can get you money compensation, punitive damages, and other types of relief, such as medical care, attorney's fees, and costs. And so with that, you would consult a private attorney to seek filing a private lawsuit. I just wanted to point out that some of HERA's other services include debt collection, credit reporting, financial product recommendations, mortgages, tenants, veterans and service members, and estate planning. Here's our phone number. Here's our website. And so now we're going to take some question and answer period. We're at the end of the presentation, and I'm going to look for the questions in the chat. I'm going to stop this recording, and we're going to take the questions and answers offline. Thank you so much for joining us. Thank you for your time and attention, and we'll continue with the questions.